Hi, everyone. Good evening. Carl Steinbeck here. Want to jump on this Monday night and cover some of the rulings that we saw from Judge Cannone, and they're quite a huge, massive disappointment. They are completely one-sided. They don't even follow the law or the Constitution. They're cherry picking the facts, and the way the opinion is written, you can tell it was written to be outcome oriented, not justice oriented or following the law or the Constitution. Nowhere is the Constitution even mentioned. Any of the amendments to the Constitution, none of that is mentioned at all. And the reason being, those would not do well in aligning with Judge Cannone's rulings here. So I'm going to show the first one here. This one has to do with the decision of the court for the motion limited to exclude the defense expert Michael Easter's opinion of the investigation. So keep in mind, this is something the prosecution is trying to keep out. They don't want another retired cop talking about how a botched investigation this was as to the death of John O'Keefe. And it's just really mind-boggling, and it really makes your blood boil. I'm going to try to be calm here, but I'm just going to walk through some of this here and just tell you what I think. So as I'm going through, she cites here, defendants have the right to base their defense on the failure of police adequately to investigate ... in order to raise the issue of reasonable doubt as to evidence guilt in the minds of the jury. So just the police inadequacy of an investigation, in other words, a botched investigation, that alone can cause reasonable doubt, right? So what she goes on to say is, and this is relied on as a Bowden defense, but it's also statutory. The next sentence talks about how it's followed under Section 1107 under Massachusetts statutes. And it says to support a so-called Bowden defense, a defendant may present evidence that certain tests were not conducted, that certain police procedures were not followed, or that certain information known to the police about another suspect was not investigated. That's a big one oftentimes. In circumstances in which it was reasonable to expect the police should have conducted such tests, followed such procedures, or investigated such information. So that's lifted off the statute. And what you have here is evidence. Note the word evidence. That's a key operative word here, because evidence means it's something that the defense can present through testimony of their own witnesses, their own evidence presented through experts and whatnot. So what the judge winds up doing later on is talking about how you cannot admit evidence. So it's really just baffling, and it's all just cherry picking, like I say. And it says here, an expert may, when appropriate, be used to support a Bowden defense on matters beyond the common knowledge of the jurors. And then she cites a case there, and this had to do with considering whether counsel's failure to use a forensic expert to testify about gunpowder residue and measurement of bullet trajectories deprived the defendant of a chance to assert a Bowden defense. So that's just by the wording of that, you can tell that has to do with ineffective assistance of counsel. That doesn't really so much go to the heart of the matter of whether because they didn't ask for that kind of expert testimony to be presented. Then it goes on to say the role of the expert testimony is to assist jurors in interpreting evidence that lies outside their common experience. So, okay, where's this going? Like, jurors have common experience on exactly how the procedures and evidence collection should have been handled in this case. And then she goes on to write, thus the first foundational element that the proponent of expert testimony must establish is that the testimony will assist the trier of fact to understand the evidence or determine a fact and issue. So, okay, there's not a problem with that. And then she goes on to cite a case, and it says otherwise qualified expert testimony is admissible if, in the judge's discretion. See, now she's getting into the judge's discretion, because the judge can keep this out if the judge doesn't want it in. And the subject of such testimony is not within the common knowledge or common experience of the trier of fact. And the testimony will assist the trier of fact in determining a fact and issue or in understanding the evidence. Citation is limited. So when she's circling, highlighting this word here, judge's discretion, really, she's going to sit there and say that everybody on the jury has common knowledge of exactly how this so-called crime scene investigation should have been handled? Then it goes on here to say, in support of her Bowden defense, The defendant here seeks to admit expert testimony from Michael Easter, a retired FBI agent, to opine on the law enforcement's failure to adhere to standard investigative principles, policies, and protocols in this case. More specifically, Easter's expert report indicates he will testify in this investigation. In this case, was not reliable due to, quote, the lack of secured crime scene, absence of a detailed crime scene log or evidence chain of custody, the failure to separate witnesses, which is a huge one oftentimes, the premature categorization of individuals as witnesses, and potentially biased based on the failure to investigate other suspects and obtain their cell phone records. The court cannot find or has defense counsel cited one Massachusetts case where an expert was permitted to opine on the general competency of a police investigation. Well, okay, that's a really loaded trick question, because the let me tell you how it works in the criminal law field. To find an expert to talk about a botched police investigation, first of all, there has to be one that's so bad that you'd want to, as a defense counsel, call an expert to talk about how bad it really is. And most of the times, you're not going to find something that bad and that significant that you're going to ask the court, if you're court-appointed counsel, to fund a expert witness to talk about that. And if you're a public defender, you still got to get permission and approve funds for that. And a lot of public defenders, they got a couple hundred cases. They're swamped. They're up to their eyeballs, drowning in cases, and they don't want to delay this case getting a trial by trying to find an expert and whatnot. And then you have also the folks that, let's say, don't qualify for a public defender. So maybe the folks that make more than $25,000 a year to on up to $100,000 a year. Are they really going to have the money, if they want to fight something, to have a law enforcement expert hired to talk about how the police botched the investigation on the case? So that could cost another $20,000. Plus, since you don't qualify for court appointment, you're probably looking at another 25, 30 grand on up to go to trial to contest it. So, I mean, what person that makes that kind of money has those assets available to fight it? And then, of course, people that make over $100,000, normally they are not the ones committing the type of crimes where you need to have a type of an expert witness anyway. But even if they do commit crimes, because we do see those more and more nowadays, obviously. And what we have is the other aspect is, if there's experts that are hired, think about it. If an expert's hired and there's an acquittal on the case, the defense wins, there is not a record of trial that goes up on appeal. So when the judge is talking about the court cannot find or has the defense counsel cited one Massachusetts case where an expert was permitted to opine on the general competency of a police investigation, that's because, like I say, either they couldn't afford it, it's a small state, they don't have a lot of cases where they're going to call out police corruption on the investigation, or else it's an acquittal. And if it's not acquittal, you can't find any research on it. So the way it works is, even if there's an acquittal, let's say in Canton, there at the Norfolk County Superior Court, even if there's an acquittal there, unless somebody knows about it, there's no like database to find these kind of opinions. So trial court opinions at the state court level are not searchable, they're not citable, they're not controlling. You don't find those unless you know specifically which case to look for. So they're not generally found in any kind of a brief like the defense counsel would have submitted here. And then you have the district court opinions of a federal case, however, are oftentimes cited, but not always. So only when a case goes up on appeal, which means somebody was convicted, are you actually going to have a record to see what is generally going on in the other courts. Okay. So for the court to cite this and then say the lack of authority suggests, no, you're really putting a spin on things, that during all jury trials where the defendant has been an inadequate police investigation based on Bowden, expert testimony has not been needed for the jury to be able to evaluate the reliability of the Commonwealth's case, or whether any failures in investigatory steps are sufficient to create a reasonable doubt of the defendant's guilt. So this is her conclusion based on what it said as the background of why you don't have a lot of cases like this. Then she's saying that, well, obviously these other cases, they don't need an expert, so therefore it's not reasonable. Obviously these courts find that juries don't need help with this kind of assistance and figuring out whether cops did the right thing or not. So it's just all smoke and mirrors. It's just all a sham. This kind of opinion is just absolute trampling on the Sixth Amendment right to present a defense. It just makes your blood boil, doesn't it? To think that this is how low the government goes to get a conviction on somebody, anybody. I don't care how guilty they are. I don't care if you caught them on film. I don't care if you got a confession of the crime. I don't care if you got 100 cops that witnessed it. You don't treat defendants like this in the American justice system, all right? Because it's rigged if you have it done like this. It's absolutely rigged. And so really us as common jurors in America know so much about police tactics and procedures. So how's it supposed to come out? Well, that's addressed here further on. She says Easter's proposed testimony concerns basic aspects of a police investigation, which are within the common knowledge of a layperson. Really, all those kind of things of how the evidence is collected, where they collect it, what to do to preserve the evidence, how a chain of custody is important. All those kind of things. I guess you all are experts, right? You all know exactly how that goes. You've seen enough crime shows on TV, apparently. And then she goes on to say this absolute ludicrous comment. Through zealous cross-examination of police witnesses, the defendant can cast doubt on the reliability of the investigation by demonstrating how it differed from standard police practices and procedures, and can raise the issue of potential bias by police action or inaction as counsel did effectively during the first trial. So she's citing the first trial. She should not be citing the first trial at all. And the first trial was a mistrial. So there was not a defined outcome that was satisfying to the prosecution or to the defense. So several times she does this where she cites something that happened in the first trial. This case is, things can change during from one trial to the next. So we're trying to do a reach back. Well, this didn't happen in the first trial, and so therefore, why should we do it now? I mean, strategies and tactics change. So, but when you think about it here, so she's saying that the only way you can present evidence is through cross-examination. Well, guess what? That's not presenting evidence. That's impeaching a witness, but that's not presenting evidence per se. Because guess what? If the witness denies that anything was done wrong, think this through. If you get up there as a Commonwealth law enforcement officer on the stand, and even if it's a former law enforcement officer like Proctor, and if they just say, no, everything was done by the book, the defense can say, well, what about this rule? What about that rule? And they could just say, well, yeah, it doesn't really apply because we had, exigent circumstances here. We had snow. And so we don't have to worry about that. And this is the way we normally do things. I say, yeah, that's maybe in other states, or yeah, that's in the book. So that's not really the way we do it here in Massachusetts. And so what are you stuck with? You cannot present any rebuttal evidence to that to say, no, this is the way it should work. This is the way it works in police training all across America. It's all standardized. Crime scene preservation is a golden rule. It's all out there for everyone to know. If you're in law enforcement, they have forensic evidence units that show up and process stuff after the initial responding officers. And so they can just completely spin this around, and defense counsel are going to be sitting there only left to try to poke holes on cross-examination. And wow, it's like what a farce this whole court is. It's absolute abomination. And then it goes on to cite some other cases where Bowdoin defense was supported by testimony listed from a police investigator. They did not conduct a criminal history check on the third party, waited a week to interview him, and conducted the interview for only about 10 minutes. Well, guess what? Okay, there wasn't an expert there. Well, you know what? The defense should have had one. But for the reasons I said earlier, that's why they didn't have one there. So it's really just it's just a way to hide the truth, keep the Commonwealth looking like everything they do is in the right and everything the defense does is in the wrong. And I guarantee you what, though, this is going to be reversed on appeal. This ruling right here is so much an affront to the Constitution, the Bill of Rights, the Sixth Amendment right to present a defense, to compel witness testimony that supports what is your theory of what happened in the case. And so that's the one saving thing about it. So then she goes on to say that the court finds that expert testimony is not needed for the jury to determine whether or not the investigation was compromised by any failure to follow procedures or pursue other suspects. So think about it. Every expert that the government wants to bring in, they get. Ones that the defense wants to bring in, they deny. It's really bizarre. And we'll get to ARCA here in a minute. And if they cite any case here within the judge's discretion to preclude testimony touching on the alleged relationship between various interrogation techniques and false confessions, okay, if there's a case that's stuck on appeal, trust me, this case, there's money behind it. It's going to go into the federal system again. There's no federal court that's going to rubber stamp this absolute insane, absolute crazy way of denying Karen Reed and her team the constitutional rights to bring this expert. Then she goes on to say the defendant is undoubtedly permitted to pursue a Bowdoin defense, and the court will give the jury a Bowdoin instruction if requested. So yeah, you can bring the defense. Well, how are you supposed to bring the defense if you can't present evidence? She's cut him off from presenting any evidence. You can only cross-examine. Cross-examination is not presentation of evidence. Okay? It's a way to the jury to think about, hey, what's really out there. But to me, that's not, and I would say most trial practitioners, unless you can prove it through what we call extrinsic evidence, if the witness denies it for your opposing side, then you have an inherent right to rebut it. Okay, this is a critical aspect of the case. It's statutory, it's in case law, and it's constitutional wise as well. And there's tons of other states that authorize this. There's federal cases that would authorize this. So she's not citing any of those. And so it's just all, like I say, a rigged system. And the only way they can win is with the judge supporting the prosecution's attempts to hide the truth. And even then, I think they're going to lose, but the evidence is that bad. And I think there's, at worst, it's going to be a hung jury for Karen Reed. So it says here, the defendant is undoubtedly permitted to pursue a Bowdoin defense. The court will give the jury a Bowdoin instruction if requested. However, juries are perfectly qualified to evaluate the adequacy of police investigation in this case without the assistance of an expert testimony proffered by the defense. Absolute garbage. This is like, there is no justice in this court. It's a constitutional free zone. It's what an absolute disgrace. I'm embarrassed as a lawyer to see this kind of stuff's going on in America. Keep in mind the Constitution, we have an oath. Everybody, like including this judge, including anybody in the military, including law enforcement, we all have an oath to support and defend the Constitution against all enemies, foreign and domestic. These people are enemies against the Constitution up there. Flat out, they're enemies of the Constitution because they ignore it, they trample it, and they just stomp all over it with this kind of garbage. For the prosecution to try to do this kind of thing, it's outright evil. Okay, it's outright evil. It's so disgusting. All right, I'm going to get off that. If you guys have any questions on that motion, I'll go ahead and cover it before I get to the other points. Hey, Leo. Leo's wondering why I'm so fired up here. All right. Gary Rudner asking, do I think there's any chance the feds contact Morrissey before trial 2 gets started? Surely the Fed knows. Well, I did see that the feds have subpoenaed the defense team's entire file, so this is not over. And this Hank Brennan, he thinks this thing's going to be over, and he's going to be able to hide all the truth from coming out, and he's going to be able to get a conviction on Karen Reed. I think there's a lot of stuff that's going to come down the pike here. Some people need to be locked up on this one, I'll tell you that. John Courtney, the technology companies are in bed with Commonwealth, are going to mess with the data. I don't trust some of these experts that the Commonwealth is going to line up. And, you know, maybe they're a new business. Maybe they haven't testified in a criminal trial before. Maybe they want to build up their business, and maybe they know what the prosecution is looking for, so they can say some things that maybe aren't accurate. And people's lives are on the line. Karen Reed's life is on the line here. So I do have that concern as well, and I wouldn't trust anything the Commonwealth puts up as a witness. Period. Absolute third world banana republic, communist type Nazi sham court. That's how I look at this. Christine, you're asking, is there any that can intervene and stop this sham? Well, I think it's going to go through for the full trial. The feds are really slow to react, and we'll see what happens. But I think there's going to be, I think just for the prosecution to know that the FBI is still looking at this, U.S. Attorney's Office, I think it ought to send fear and strike fear in them, because what they're doing, I think is an absolute crime the way Proctor handled this case. There's a civil rights statute that talks about the kind of stuff he did to trample on the civil rights of Karen Reed. And so maybe they're going to go after stuff like that and get him to flip or something. So, yeah. Yeah, Elsie, no, that's what I'm saying. The feds have not dropped it because they just asked the defense counsel for their entire file. And you know who they're not asking it from? The Commonwealth. They don't trust the Commonwealth. They're investigating the Commonwealth. That's what it tells me. Yeah, this is Leo here, so he's happy we're back, aren't you, Leo? All right, let's see here. What do you mean I'm finally ticked off about this? I've been ticked off about this a number of times. And this is not the only case. The Adelson case, another one I've gotten ticked off at. Lid Rich, you're asking, could the lawyers ask that there be questions related to potential jurors' competency around police protocol? Well, that's something that I think she opened the door to. So hopefully they'll be able to do that. But I think she's going to try to shut this down. I think jury selection is going to be so tightly controlled, and it's just going to be part of the thing that the judge is going to do to pick the foreman, pick his alternates, so she thinks that could be less favorable to the prosecution. It's all a rigged scam. Okay, she should not be allowed to pick numbers without other people overseeing the numbers she's picking. She should not be involved in it at all. Let me back up and say it. She should not be involved in it at all. And so this should be something that's totally transparent. When you don't have transparency, it feeds corruption. Yeah, I just don't think, with all the chaos going on, I just don't think they're going to get 12 people. There's not going to be 12 people that agree with this garbage, this ash and trash garbage. I did not watch the Game Burgers. I did not watch this trial. Okay, there you go. So it's done all around America, but you got a black hole there in Massachusetts because corruption runs deep for many centuries. Okay. Arctic Cat, you're saying this giving law enforcement across the nation a bad rap. You have children in law enforcement whose partner was killed in line of duty. Yeah, I mean, but at least you can see there is bad, but there's also good. Not every court is like this. Far from it. There's very, very many courts that are excellent. The judges are excellent. I think more and more as time goes on, though, the justice system is failing us in a lot of ways, and nothing as bad as the failure of this court, though, that I've seen. Chatty T is a possible regular jury. I sure hope not, but I have bad feelings about it. Well, they could always, everything's supposed to be random, computer generated, and all that kind of stuff. But I don't trust anything that's coming out of that court. I don't care if it's clerk of court's office. I don't trust anything. So But I think for them to get 12 people on the jury that are all in the back pocket of the Commonwealth, I don't think that's going to happen. So I think they're not going to be able to get anything more than a hung jury. Mr. Monk's understated. In hindsight, do you think the defense should have put Eastern and another similar expert on their list initially? Then Judge Cannone would have to strike both. Yeah, that's sort of, if you got more than that, first one, then is maybe puts a little more pressure on her to not deny both. So that could have been a good strategy, but you have to get the defense expert hired and review the case and study it. So that costs a lot of money. So normally it's cost prohibitive. Yeah, I'd maybe look at some kind of writ of mandamus. Unless they just want to roll the dice, the defense wants to roll the dice and let this play out and try to get the acquittal. But a writ of mandamus is like a higher level court petition to get the judge to be ordered to do something that they're abusing their discretion on. So I think this would qualify her out of control rulings, but don't know if they're going to do that. Nick Smith, you're saying this is happening all across America, from what I understand. Well, it happens in a lot of places, but it's not every place, okay? It all depends on the culture. A lot of it's led by the district attorney, how much it's a good old boy system. If it's a culture of due process and they respect the Constitution, you're not going to see this kind of radical decisions. You're not going to have a judge this bizarre in their rulings. Ellie, you're saying, I think the feds want to watch the trial play out. I think they can't do to their level of degree to put JL physically in the house. They want someone to slip or flip. That could be very well the case. Yeah. Let's see how the Commonwealth messes this case up. Reasonable doubt. Yeah, Bev. Well, I'm going to call her by judge. I don't want to use a first name for a judge. That's not respectful for an attorney to do that. So, despite me having strong opinions on the lack of following the law, the Constitution, I'll always refer to her, and I ask you to also refer to her as the judge or Judge Cannone. And Emily S., you're concerned that Karen Reed will end up in jail for them get to a fair court. Yeah, I mean, do a motion, some kind of a writ to get this judge off the case as well. There's got to be something they can find on her that shows her bias, or some kind of connection with Morrissey. I mean, basically, it's like having Morrissey on the bench. But the problem is, it's not going to survive appeal. Trust me, folks, it's not going to survive appeal. So as bad as this gets, there is going to be some justice in the end if she does get convicted. I think one thing also is going for the defense is that we have so many jurors will be looking on their phones when they get home, or their computers. They want to see exactly what the real story is about this case. They're going to be seeing a lot of channels out there on YouTube and social media. So I think that they're going to what? So this effort to hide evidence and stuff like that, I think some of the jurors are going to see that. So I think it could really backfire, and they're going to say, "What? The prosecutor did this, and the judge agreed to it? Wow, this is a scary system." Elsie's asking if are they going to retry her if this is another hung jury. I think they will. I think they'll go for it once more. Full male hash values. This court is a mockery of justice. I totally agree. Lisa Lee, you're saying I don't trust our witnesses either. I don't think they really care what we think because they have the judge on the bench on their side with the power to do damage to human innocent life. Yeah, I really can't believe that they're that stupid to embarrass themselves this way. That they really show how one-sided justice is up there. Okay, just looking through some more questions here. Okay, Nikki, you're saying this whole thing generally wants to make me move out of Massachusetts. Boy, I mean, this could happen to anybody, okay? Anybody in Massachusetts. If you get mixed up in the wrong scenario and they'll deny you a fair trial like this, yeah, it is absolutely scary. Do you get any vibe from this judge that she's concerned about due process, a fair trial? Do you sense any of that from the prosecution, that they want to make sure Karen Reed has her constitutionally protected right to a fair trial happen? No. All it is hide anything the defense is trying to do, to hide and make up stuff, make accusations, say there's no evidence of anything the defense is saying. It's just, this is the worst I've ever seen it. I don't think I've seen it, well, anything this bad. Gary Rubner, how did they plant the jury foreman in trial one, and why did those people cower to him? I think the defense made a mistake. I really think anybody with law enforcement background, and you're trying to show police corruption, were they thinking maybe that he would explain to the jurors that, yeah, this was so bad, they botched this things in a massive way that we really don't know what happened out there, because they never interviewed these witnesses and got them locked in a room and with a camera and put them under some tough questioning. Robin Hood saying you only watched parts of the first trial and you were incredulous about this judge. Yeah, I mean, she has no persona of a judge, I'll tell you that. She doesn't come across with any kind of persona where she's making sure justice happens in that courtroom. Yes, Olivia Nile, you're saying her rulings are terrifying. She's playing the role of fact finder, jury, and executioner. Yeah, that's one way to say it. Hank's lack of grace. Where's our retired North Carolina trooper tonight? Well, actually, I talked to him tonight, and we're gonna do a live stream tomorrow night. I'm gonna interview him. We're gonna talk about it, and he's gonna talk about things that should have been done. So I've never done that before. Had an expert on this channel, so I'm going to do that tomorrow night. That's the plan, anyway. Pebbles, you're saying that was said at the last trial too. The feds were waiting, and then nothing happened. Well, we'll see. LC, Carl, in your experience, have you ever seen a potential conspiracy this large? This is not that big of a conspiracy, actually. All it takes is a few folks in the house, a number of law enforcement officers there in Canton, in the DA's office. It's not that big of a conspiracy. And a lot of people just look the other way and they never really want to peel back the onions and say, hey, wait a minute, why is Proctor not doing this and that on the investigation? In fact, why is Proctor even doing this investigation? Because he has a conflict, a personal conflict. So I think most of it is just they just look the other way. I don't think people are actually sitting in a room saying, hey, how can we pin it on the girl? There's a few folks doing that in something like this, but it's not a large number, I would say. And a lot of times the conspiracy is not so much those that are the actors, but those that are doing the cover up. Those can have a lot more people involved. Rich Chick, you're saying, did you notice a change in Judge C's rulings once the FBI said they're done? I think that emboldened her. They think, hey, we're clean. They got nothing on us. So this ought to like scare her. This ought to send some message to her saying, you know what? We know stuff is running dirty here, and we're going to get to the bottom of it. Okay, next I'm going to cover this other case here. This other opinion. This one is Judge Cannone's ruling on the motion to exclude defense. Oh, I'm sorry, that's not the one. Here we go. Didn't overwrite it here. All right, this one here, this has to do with the third-party culprit defense. Keep in mind, at trial one, they didn't specify any names. Then Yannetti in court a little while ago, 2 weeks ago or so, he actually, when the judge says, well, do you have names? Can you give us names of the third-party culprit? And he said, yeah, actually we can. And then he cites the three, Colin Reed, Brian Higgins, and Brian Albert. And so I was sort of wondering why he would do that, because it sort of locks him in, and it gives the judge a chance to deny you that in the beginning as opposed to developing it during trial. So what happens here is that she grants the Commonwealth's motion to keep this from coming out. And again, this is a Sixth Amendment right to present a defense. If there's a botched investigation, they never treated anybody else as a suspect other than Karen, and the folks there at the scene could have motives and be involved in something as well. And so this is like huge. It's a huge requirement to make sure due process happens to Karen Reed. So, and here she even cites this in her opinion, that the opportunity to present a third-party culprit evidence is guaranteed by the due process clause of the 14th Amendment because it's rooted in the right of a criminal defendant to a meaningful opportunity to present a complete defense. And that's citing Massachusetts law, which is actually quoting Crane v. Kentucky, a U.S. Supreme Court case from 1986. It goes on to say a defendant may introduce evidence that tends to show that another person committed the crime or had the motive, intent, opportunity to commit it. Then she cites other Massachusetts case. But then, of course, that's not the end of it. Of course, she wants to say something contra, which is like, however, defendant's latitude to introduce such evidence is not boundless. Again, a Massachusetts case or two she cites. Evidence that a third party committed the crimes charged against the defendant or had the motive, intent, and opportunity to commit the crimes is admissible, provided that it has substantial probative value and will not tend to prejudice or confuse a jury. And then at another Massachusetts case from 2015, it says proffered evidence must have a rational tendency to prove the issue the defense raises, and the evidence cannot be too remote or too speculative. Well, the only reason to be remote or speculative is because of things like the shoddy police investigation, right? That's one of them. So anyway, she goes on to talk about Colin Albert. And Colin Albert, it says the defendant's proffer contains no additional evidence that was presented at the first trial and is insufficient to support a preliminary finding that Colin Albert had the motive, intent, or opportunity to commit the crime. The evidence of opportunity is wholly inadequate. There's no evidence that Colin Albert was at 34 Fairview when the defendant, Mr. Keefe, arrived at the home. So she's already taken the side that what the prosecution witnesses say it's golden. It's unimpeachable. There's no point of even trying. It's really bizarre. That's the whole point. She's cutting off the defense at the knees here. Then she cites a case from 2012, again, Massachusetts, where it says third-party culprit evidence properly excluded where there's no evidence third party had means or opportunity to commit the crime and evidence of motive was speculative and too remote. Well, he had bashed up knuckles. They're all bloodied and scraped up. And of course, he was never disclosed initially as being in the house at that time. And if he's not mentioned as being there, and then it comes out that he was actually there, maybe he wanted to get the heck out of there, not be drug into this as well. They're trying to limit the number of witnesses they had. Maybe he had injuries they didn't want the police to see. And so it's just absolutely ridiculous to sit there and say that. And this case law, by the way, is so restrictive. I think this case law is unconstitutional as well. Let them present it. What do you got to hide? If it's not the truth, then let the jury decide it. Let it get before a jury. Evidence in the first trial was that Colin Albert had already been picked up by the time O'Keefe and the defendant arrived at 34 Fairview. So, but if the defense can't dispute that and argue anything different because he testified to that one other time, absolute rigged outcome here. As to motive, the defendant contains that Colin Albert had been in a feud with John O'Keefe in the weeks and months leading up to O'Keefe's death, and that Colin Albert had thrown beer cans on O'Keefe's lawn and swore at him. There was, however, no evidence substantiating these claims at the first trial. Even if there was evidence of some ill will between O'Keefe and Colin Albert, motive alone is not enough to demonstrate third-party culpability. Again, you got the garbage opinions there from Massachusetts. Fact of tensions between the neighbor and the victim was not indicative of the neighbor's motive to kill, and the defendant offered and produced no evidence suggesting that the neighbor had any opportunity to kill beyond that possessed by any other neighbor. I mean, just absolute trash opinions by these courts. So it goes on to say, moreover, the theory that Colin Albert is a third-party culprit because he had scraped knuckles at some point after O'Keefe's death had been seen in video drunkenly taunting others with no connection to O'Keefe, and apparently was not named in police reports, is speculative at best. Speculative? Well, part of it's speculative because they were trying to hide the fact that he was involved, is what the defense is trying to argue, and they should be allowed to argue that. The police never investigated anything of injuries on any other parties there that night at the house like they should have. So the defense is left. They can't force people to show what their hands look like, show what injuries they might have on their arms or chest. So it's just really, like I say, a rigged system here. There's even cite here evidence that a rival gang members lived near the shooting or were involved in a feud with the victims was not sufficient to support third-party culprit defense where there's no evidence they had been nearby at the time of the shooting, and theory was speculative at best. Well, you know what? That should be allowed, and this is just a denial of Sixth Amendment right to present a complete defense. So then the judge says that accordingly, she says that his third-party culprit. That is a defense for Karen Reed is going to be excluded from trial. So then now they cannot accuse him of being part of the attack on John O'Keefe. It's just absolute disgrace. Then she goes on to talk about Brian Albert and Brian Higgins. Then she says their proffer is barely sufficient. The defense's proffer here of how they should be allowed to argue that they're the third-party culprit, or at least suspicious of being them. And the history of the first trial cast doubt on the seriousness of the claim. However, to protect the defendant's right to a fair trial, okay, and then in recognition of the fact that the defendant has no burden to prove anything under our law, the court will take the same incremental approach as did the first trial. Defense counsel are ordered not to mention potential third-party culprits in opening statements, but counsel will be allowed to develop the evidence at trial if possible, and counsel may seek appropriate instruction if warranted after the evidence is concluded. So there she goes. She's trying to keep it out, folks. You may not see any third-party culprit defense instruction here. Although the court may ultimately exclude the proposed third-party culprit evidence, or the court may abandon the theory, that does not mean the defendant cannot offer the evidence to show the adequacy of the police investigation, provided the proper foundation has been established. So all these hoops and burdens for the defendant, prosecution, they just get to bring truckloads of the garbage they want in. But the defense, no, you're not going to get a fair shake at this. So again, she goes on to say the defendant is not prohibited from raising a third-party culprit defense to Brian and Albert Higgins at this time. Counsel cannot mention potential third-party culprits in opening statements. I'll be given the opportunity to develop the theory through the relevant, competent evidence at trial. This is such garbage, folks. I mean, these are the most likely suspects. If you take the notion that the car did not strike John O'Keefe, he was somehow beat up and attacked by a dog or some other animal, who is the most likely suspects for this? The defense should not have to be able to prove that they did it. They were not able to act as an investigator when the death happened. You have to rely on, what's provided in the police investigation. So now you can't bring an expert for the botched police investigation. You can't point the finger at these other folks that they should have been there as well. And you could actually, as the defense, unite the two. And so this expert could say they should have investigated and considered everyone in the house a suspect until they find otherwise. But now they cannot do that. So they're hamstringing the defense. They're got their arms tied behind their back. They're blindfolding them, and they're pushing them through a maze, hoping they stumble and fall in front of the jury and embarrass themselves. So I have no respect for this opinion, none whatsoever. Septic Hank, you're saying that judge is the chief prosecutor as far as you're seeing this trial. I give her far too much benefit of doubt, and 1.0, I see that now. Yeah, some people are saying how, this judge is fair and all that kind of stuff in the beginning. It's like, wow, she is not fair at all. The worst I've ever seen. You're saying that judge is another special prosecutor. Yeah, I don't want to get into these names. You're talking about Morrissey. I saw there's a Boston. It's not the Boston Globe, but there's a scathing report that came out that I saw today that was all about Morrissey and then the kind of corruption legacy he's leaving. Letteros by Betterow. This is not bias. This is corruption. Yeah, it's just rigged. Okay. Do these people really not have an understanding? Boston Herald, there it is. Do these people really not have an understanding of the Constitution? Yes, Andy, that's a good way of saying it. The judge is trying to make the defense prove their case instead of the other way around. That's really how it's coming across. Yeah, give the Fed some time. Hopefully they'll come through. Okay, somebody else saying the Herald. Yeah, you guys check out that article for the Herald. Reasonable doubt. You're saying, can we expect more gaslighting from ADA Brennan done with Judge Cannone? Apparent blessings. Yeah, that's all it is. It's all smoke and mirrors, gaslighting type of stuff, misstatement of the evidence. That's the only way this guy's going to win. Misstating the evidence, denying the truth from coming out from other experts. Yeah, Mellon Derp, you're saying when the defense said the feds filled the subpoena, were they saying it was reason? Yeah, it was 20 March of this year. Well, they did a subpoena for the defense and all their files. So that to me tells me that they're looking at the Commonwealth. Buttercup 203. Yeah, that's what I'm trying to do. Remind you that the Constitution needs to be upheld. These ridiculous Massachusetts state court opinions, that once this gets a federal court, if she ever gets convicted, they're gonna like rip these to shreds. They're gonna go by the real Constitution, not the Massachusetts version of it. Miss T and Eddie, you're saying it's basically let's make this impossible for the defense again, but worse. Yeah. So think about this, how scary this is. You have your right to present a defense is being absolutely gutted by this judge. The prosecutor is asking for it to happen. The judge just rubber stamps virtually all of it. The only thing she's not rubber stamping the prosecution are things that would absolutely shut the whole case down, like him trying to get the attorney-client privileged messages. But everything else, she's looking for a way to try to grant it for the prosecution. Okay, next, let's talk about the ARCA witnesses. I think those two experts for ARCA, by her saying that they're going to be voir dire before trial, what that actually does is also, again, she's hamstringing the defense from being able to mention these ARCA witnesses will testify, because right now we don't know if they're going to be allowed to testify. And this Hank Brennan is trying to argue that they haven't complied with discovery reciprocal requirements, and so that he's going to try to argue to keep them out as punishment for the defense not complying with deadlines. So it's an absolute thing where he just makes something up. Judge is going to follow him, and so I'm wondering if the ARCA witness would be even allowed to be testifying for the defense at this point. That's what a rigged disaster this thing is. There's one other thing here. Sorry, Leo. Oh, yeah. And then in conjunction with that, there was something that came out. I didn't see it posted anywhere today, but let's see, where is this? There was a ruling that was on masslive.com, and it talked about how the Kieran Reed case defense can't tell jury key experts were hired by the FBI. So even if she does allow them to testify, you can't have the defense bring out the fact that they're hired by the FBI to evaluate the prosecution's theory on whether the vehicle had actually struck John O'Keefe or not. The only reason the FBI did that is that they suspected foul play in the way this prosecution was handled, the way the law enforcement investigation was so botched up. They thought something else is really wrong here. It's not making sense. We don't trust the Commonwealth theory, and that's what they spent money on to contract out to hire these ARCA experts. So for her to deny that fact from coming out, it shows you how rigged it is. And we even heard from that juror, Ronnie, is saying that could have made a difference. So they know they're hired from the FBI. They discounted their credibility because they thought they're just some insurance type investigators. So, I mean, that's the kind of knuckleheaded thinking you have on the jury, that that you need to bring out the truth that these guys were hired initially by the U.S. government. They consider them that credible that even the FBI doesn't have this kind of expertise. They had to go out and resource it, and ARCO did a phenomenal job. So I just wonder if this judge is going to look at some kind of a Rule 14, Rule 17, whatever that rule is that they have for reciprocal discovery. I think it's 14, and basically just gut the defense entirely of these ARCO witnesses. All right, let's see here. Reasonable doubt. You're thinking that she's going to block ARCA as well. I mean, that's what she's teeing this up to do, to try to blame it on the defense counsel. Say, hey, you didn't comply with my order. So, yeah. Ann Smith, what's your loyalty to why Judge Cannone so biased? I think it has to do with the Morrissey connection, and there's going to be some kind of payback down the road. Maybe he's going to help catapult her to be some Supreme Court justice or something like that. Who knows? But there's something that's absolutely behind the scenes going on. You don't go from being a career public defender to having these outrageous trash the Constitution rulings. Can you imagine her as a public defender? Public defenders that, like I say, don't want to go to trial. They got too many cases. They just try to get everybody to plead guilty. Was she that kind of public defender? Why would you get a ruling? Anybody that should understand the Constitution, it should be a defense counsel that becomes a judge that can then apply the Constitution. That's what she'd have been arguing if she's filing motions for her clients. Nikki, this is a good point. Let's not forget the Commonwealth almost has all new expert witnesses, yet the defense can barely get the ones they already had in the first trial, let alone anyone new. Yeah. I mean, this is that really is a great point to make. It's really rigged. Okay. Yeah, and yet the Commonwealth says Kate can withhold evidence in those cases because we're already going to a new trial. Everything's secured. Buttercup, you're saying, let's see if the judge rules the same in trial 2 as she did in trial 1. Yeah, I think it's going to be, it's not going to get better, folks. The only thing that's maybe redeeming the defense is that the feds are still looking at this case. And I think they're looking at her too. Law enforcement, district attorney's office, and the judge. Well, something's going on there. It looks very fishy. Charlie Lynn, you're saying that Hank is going to try to question them to make them look bad, and the defense won't be allowed to say why. Yeah, he's just gonna do a complete smear campaign against these guys. I mean, he's just it's just I got to bite my tongue because I'm going to say some stuff. It is an absolute. Makes you just want to just turn it off. It's that bad. But I'm going to keep following this case, and Katrina Raven, you're saying, can the defense file a motion to reconsider these rulings based on the failure to abide by the Sixth Amendment in the Constitution? Well, they could use other case law that's controlling it, could use federal cases and stuff like that. And I don't think they've probably relied on that enough to try to convince her. Because these cases in Massachusetts, it's very much a straitjacket, unfair system up there for the defendants. For many of these cases they're citing in a summary of what they held, it's that statute's good. It talks about them allowing to present a Bowden defense, present evidence, but then the judge says you can't present evidence. You can only cross-examine it. Well, that's not evidence. Unless they admit it, that's not evidence. You're arguing it, and if they deny it, you're stuck holding the bag. And what do you have to prove a rebuttal? She's denying a rebuttal of things that they'll lie about and say it was an excellent investigation. Yeah, if you have questions, use the red emoji. That helps me. Pebbles, you're asking why the Fed's looking at Commonwealth? Because on the 20th, we found out that Yannetti made a statement that the Fed's asked for his entire case file. That's how we know that. And that's of this year. 11 days ago, he said that. Long late 8027. Do you see the joint witnesses? It's alphabetical by first names, that Aiden Kearney is first and Alberts are not. Yeah, that's something. Yeah, I think Brendan's promised a judgeship, and that's the other thing is that Brendan. Think about it. That's why I don't like special prosecutors, because they're just going for broke. They don't care about trampling on the rights, because you know what? He'll get his $400,000 or $500,000 out of this when it's all said and done, and they'll move on, and then they'll give him a judgeship, or he'll replace Morrissey, and that'll be extra motivation for him. So. And then, unless he becomes Morrissey's replacement, he doesn't have to deal with the aftermath. And even if he does wind up losing this case on appeal, he'll just go after her again. And so, yeah, it's just really bizarre how this whole thing's shaken out. NFL Rising, you're saying, I doubt any Judge Cannone's bias went out the window the day she stopped court for her grave concerns. Regardless of bias, she has zero judicial temperament. Yeah, she just doesn't have the demeanor, temperament that you would expect of a judge. And that's what I've been saying also, JM. The judge's attitude is perfectly meant to make the jurors think the defense's theory is ridiculous and a waste of our time. Karen clearly did it. It's so obvious. Yeah, that's the kind of attitude she has. I agree, and I've been saying things along the same lines. Arnie asking, have I ever seen so many accomplished, credible lawyers to be this united in their understanding of case or rulings? Every lawyer online seems to be in agreement. Yeah, I don't really am following much what other attorneys are saying. I guess there's maybe 4 or 5 I've heard of, but I'm not really listening to what other attorneys are saying about this case. Bits and pieces I hear, but that's about it. Mr. Monk's understudy, the Commonwealth is claiming Karen's vehicle is a murder weapon, and they are destroying her expert witness on the vehicle murder weapon. So the only, like I say, they want the truth has to be hidden, kept from the jury in order for them to win. I like this point as well, Charlie Lynn. You're saying no expert needed for a Bowden defense, which can be a basis in and of itself to get a reasonable doubt by the jury. That's noted in case law in Massachusetts. And it's guaranteed you can present evidence by the statute. But the meteorologist testify on the ground is that the ground is hard, she allows the door to remain open on that. If he can build up his expertise on that'll probably come in as well, besides just him talking about the weather. So definitely, again, one-sided rigging for the prosecution. Blue Lays, you're saying as a woman and mom of a daughter, it's terrifying to live here at this point. It could definitely happen to anyone, but women need to be very careful here, in my opinion. Yeah, that's the other thing, as I understand it, the law enforcement up there is unionized, so they have a real ability to keep some of the bad officers still on the force. Copa, you're saying what defense would Karen be allowed if all of Brennan's requests are granted? They want to leave with no defense. I mean, that's almost what it might come to. Yeah, if these ARCO witnesses are kept out, man, that's. But they don't care if they get a conviction. I mean, if there are ARCO witnesses are kept out, I think if that was done because she's saying that defense counsel messed up on the timelines, didn't get enough to the emails and whatever communication there was between the defense and the ARCO witnesses, if they're kept out for something like that, then that could be ineffective assistance of counsel. Maybe Karen could win it on that ground. But I think coverage of this case, people talking about it, is helpful to the defense. Lawyers saying this case breaks your heart. They know we know it's corrupt and they don't care. We know. Yeah, they don't care. They just. All right, and you're saying the moral story to me is never move or visit Massachusetts. This whole case has diminished my view of that entire state. Yeah, we were in Boston. When was it? About 6 months ago, I think. That was my first time there. So I didn't make it down to Canton, but fierce like Frida, you're saying, I wonder if the Senator Birchmore case, the opposite will occur. The Commonwealth is to try to give the defense everything they need to deem that police officer not guilty. Well, here's the problem with that point is that it's not the Commonwealth prosecuting that case, that corrupt officer. It's the Fed. So, yeah, I agree with you. The Commonwealth was doing it. Well, the Commonwealth said it was a homicide. I mean, a suicide, not a homicide. So, and now the Feds are prosecuting it as a homicide. Thanks, GR Cuber's asking, is there any chance the defense has a ton of new evidence that we're not privy to? You know, the thing is with these experts and what we're hearing about the experts, if they had a good expert, Brendan would try to keep it out. So I think there's maybe some digital evidence that's going to come out. I'm hearing about the phone swipe of John's phone was done around 12:31, 12:32. So Karen was already on her way back to John's house. So if that's the case, really, so we knew he was moved. His body was moved, or he was walking himself 80 steps up and down 3 flights of stairs. So how does his phone then be swiped off, and then how did it wind up under his stomach? None of this stuff adds up. Carrie B saying you'll never drive to the Massachusetts, you're 10 minutes away. Jam, seriously, what's the point of the Constitution? A judge can blatantly violate our rights with no repercussions. Yeah, I mean, in that setting, unless you got the resources to be able to go to the federal system, that's your only hope. PJ, what is power and wealth while losing your soul? Man, they don't. They think they're getting something good by trampling on her rights, but it's not going to work out good in the end. That'd be nice if the FBI does something here still this year to undo this hot mess. All right, I'm gonna get off here early. PJ, you're saying pretty much all the attorneys on the same page. So yeah, that's good. That's good. I can't believe I did hear there's one attorney that I don't know anything about his background, but I heard there's one attorney that said that this I think he was on Court TV where he said basically the state's going to win this case, and it's Karen Reed's guilty and all that kind of stuff. The guy obviously didn't know anything about the case because he said that Karen Reed backed her car out of the driveway. So then right there when he said that, I knew he didn't know much about the details of the case. Okay, Buttercup saying everybody on YouTube agrees with that's a lawyer. So okay, that's that shouldn't be hard to figure out if anybody follows this case to any degree. All right, so that's what I'm going to cover then for tonight. Pebbles, you're saying Court TV is terrible, most biased. Yeah, that I've heard it. I haven't seen it, but I heard that they've turned on Karen, and I heard Julie Grant was all pro Karen, and now she's against her. And I don't know if that's true or not, but in any event. I still think the digital stuff, if this jury has got half a brain, if they didn't check their door at the scanner when they came in the courthouse, then, as somebody said that today I saw, then Karen should get acquitted, even with all this suppression of the truth. And like I say, in worst case scenario, there's no way I can see her being convicted. So I got to have faith in that jury, despite the fact that it's a rigged system. Eliza Corrigan, you're saying, I know the details. You have reasonable doubt for sure. You can't get past the Albert's not coming outside with a dead body on the lawn. And it was a person they invited to the house. Yeah, that's. Yeah, so I plan on being at 8 o'clock Central Time, 9 o'clock Eastern with the retired police officer. So with that, thanks for your support in the Just Sons case. And we'll be back tomorrow night. Y'all have a good night. Thanks.